Hello and welcome to Big Picture. I am Vishal Dahiya and today we will talk about the family laws and the custodial rights. Now, the Supreme Court has recently sought Centre's response to a PIL which challenged validity of a provision of Hindu Minority and Guardianship Act 1956 that prefers father as a natural guardian of the children till they attain majority. A bench headed by Justice Arun Mishra issued notice to the centre after petitioner's counsel argued that the 1956 law's gender-biased discrimination for grant of guardianship of children violated the constitutional right to equality granted to Hindu women. The Apex Court had earlier issued a similar notice to the centre last month on another petition seeking revisit of country's all personal laws with regard to the custody of child in matrimonial disputes. Earlier, the 257th report by the Law Commission of India had also suggested amendments to the current statutory provisions so as to include the provision for shared custody or joint custody. For more on this, we're joined by a distinguished panel of guests in the studio today. Let me first introduce, we have with us Mr. Shyam Suman. He is the legal correspondent of Hindustan. We also have with us Ms. V. Rajyalakshmi, sociologist, Janki Devi Memorial College, Delhi University with us. We will also be joined by advocate from Supreme Court, Ms. Rekha Agarwal. But meanwhile, let's begin with Mr. Suman. Mr. Suman, these are two different petitions and seemingly quite important and a bit similar as well. So what are we looking at in terms of the pleas filed by them and what are the laws which are being questioned by these petitions?
The law is questioned on the ground that this law is discriminatory in respect of the women, because court said if the child which custody is sought, if below the 5 years of age, the mother is a natural guardian. But if the child crosses 5 years age, then father is preferred as a natural guardian. This is the law, and the petitioner's challenge in this law, in this point is, she said, she is a retired army officer, and she said that this law is gender discriminatory because it prefers father as a natural guardian while mother should be the natural guardian in this case. The court has sent notice to the central government, and I think the central government will respond to it. But to my understanding, the law as it stands today is quite well, because in if I may elaborate further.
Yes, please.
Yeah, the court, whenever custody matter comes in the court talks to the parents. Anyone need arises, court talk to the child also, and they talk to the child in a very elaborate manner and very detailed manner, and take stock of the situation, whether child, what would be the better interest of the child, and after that court decides. It may be mother, father or joint custody.
Okay.
In three manners court decides the case.
Okay.
This is the gist of the thing.
Okay. But the basic premise of the entire, dispute out here, or in fact, if you say the PIL which have been filed by both the petitioners is that, these laws, and specifically the 1956 law which we're talking about, is discriminatory in nature towards women.
It seems, if you see on the face of it, you would say yes, it is discriminatory. But if you see, India is not we have a different economic levels in the society. On one hand, you have an urban population where women are very economically independent. But if you go into the small towns and the villages, you will find that women are dependent wholly on the family or the husband. To keeping this point in view, government may come out with this law, and I think government will come out with the reply also.
Okay.
In the same reply, government would raise the same plea. Yes, we don't have a homogeneous society where the economic criteria is same. So that is the thing, I think. Yes.
Okay. In fact, there is a, as I pointed out earlier, there is a recommendation from the Law Commission in its 257th report as well, suggesting changes. But let's go to Ms. Agarwal, who's just joined us. Ms. Agarwal, if you look at these particular two cases, specifically the two PILs, and what the the laws which these two petitioners are challenging, the basis of their PIL is that these particular family laws are discriminatory against a particular gender, which it should not be. So are we looking at a discriminatory issue? Are we looking at rights of women or right of the children here, or is it just about shared and joint custody and the usual a matrimonial dispute and custody battle?
See, we have to take a very holistic view of the entire problem that is there before us that we are discussing. No doubt the constitution of our country says that everybody is equal in the eyes of law. Article 14 provides about that. At the same time, Article 15(3) also makes provision that there can be positive discrimination for women and children wherever the welfare of women and children is involved, particularly children. So in that light, I could only say that ultimately the court has to decide while deciding this PIS that whether there is a balancing act between the constitution on one hand, which talks about Article 14, and the rights of women and children. So both of them have to be seen with a holistic view, and we cannot say that it will be very taking a very specious view of the problem by saying that no, this is discriminatory in nature, or this is not taking care of a particular sect of the section of the society. We have to safeguard women. We have to make sure that the welfare of children, particularly the most sensitive section of the society, that is taken care of. Ultimately, everybody is equal in the eyes of law, whether it is man or a woman, but children fall into a different genre altogether, and that is what we have to see, that while doing justice for one section, we do not do injustice to the other. Okay. So the balancing act has to be done, and how we safeguard the rights of a particular society, particularly women vis-a-vis children, that has to be finally decided at the time of deciding of these PILs. Okay, we'll come to the other aspect of it a little later, but let me bring Ms. Rajyalakshmi here on this point only, which is mentioned by both Ms. Agarwal and Sham. Ms. Rajyalakshmi, the point here is that if we're looking at the situation in a holistic manner, the question which is being asked by the petitioners is that why are both father and mother not kept at the same pedestal while framing this particular law, or while looking at this particular situation? Why have father as a natural guardian listed or pointed out or written in the law itself there?
See, to begin with, all I would like to say is that our society is changing so fast. This law came in 1956. Okay, since then the family dynamics has changed. The way in which the man and women have started looking at their relationship has changed. The status of women has changed. Women has become more economically independent. The relation between parents and children has also changed. The division of labor, which used to be earlier, where the man used to be the breadwinner and the mother used to take care of the domestic sphere, that also, the whole idea, the definition has changed. With all these changes, the fact that to have a law which says that father is the natural guardian is something which I do agree with the petitioner that it is discriminatory. Why? Mainly because, see, what happens is, of course, we cannot have one law, it should be same case wise case, mainly because India is, as he pointed out rightly, that is a very heterogeneous society. There are different classes, there are different caste groups, kinship organization is also very different. We have patrilineal and matrilineal. So what happens is, if you look at the patrilineal societies, then obviously the natural understanding is that the father is the guardian, mainly because it is the children take the name of the father. The blood actually, the understanding is goes to this. So especially it becomes very difficult for a man to give up the male child. I'm not saying the female child still, he's okay with it, but to give up a male child becomes very, very tough for a man. So therefore what happens is he prefers to stick to a male child. But then again reeks up of discrimination if you're looking at this aspect in that way, the preference is given to the male child. Again this carries further why? Mainly because yes, there is. And then what happens to naturally assume that the woman is not capable of taking care of the child is something which is questionable. Why? Mainly because even if there are two things, when you say that okay fine, women is economically independent, so therefore she can take care. The women who is not economically independent, of course there are problems, because it becomes very difficult for the women's support system to take care of not only her but her children. That becomes a big issue. All these things is but to just generally have a blanket term by saying that the natural guardian is a man is something which I don't think should be really seen or accepted in today's society.
Okay, Ms. Agarwal, you spoke about the child-centric approach, and that is something, and as Shyam was also pointing out, that the courts are very mindful of the fact of the implications of this particular law as well. And when we've seen when several cases are decided, there is a very holistic view which is taken by the respective courts as well. But if you look at the child-centric approach and specific wording of the law and the way these laws have been framed, one point which we can't ignore is this is a 1956 law, where as Ms. Rajya pointed out. So has the time come now to go ahead and move towards bringing the shared parenting concept, which one of the petitioners is talking about, that it should be brought within the law itself?
See, ultimately we have reached, we come a long way, and from 1956 to 2019, and I fully agree with Ms. Rajya that yes, a lot of water has flown under the bridge, and women are not just the weaker sex as they were thought to be earlier when these laws were framed and only supposed to be fit for the kitchen. I think that time has come when we have to make gender neutral laws, and which is only when the gender neutral laws are there. For example, the POXO Act, which was enacted recently in 2013, that was one step which made sure that where the welfare of children is concerned, we have to be mindful of both little girls as well as little boys. So as far as adoption laws are concerned, or whether family matters are concerned, wherever we're talking about guardianship and custody, there could be a case where we're talking of a gender neutral environment, that the guardianship could be given to a particular parent and the physical custody could be given to another parent. So that could be that could be a sharing concept between both the father and the mother, so that ultimately the child does not suffer. The child-centric approach has to remain, because whenever we're talking about equality, I think that, in my personal opinion, the child gets an edge above both his parents. Let the warring parents fight in the court and do as much as mudslinging and as much as acrimonious litigation that they want to, but the child should not suffer. So yes, if we do have a time and that we are able to change these laws and make them more friendly, time friendly, and must accept the fact that yes, things have changed. Women are now, some women are the breadwinners. Some it may not be the patriarchal system everywhere. It could be the matriarchal system also. But in a patriarchal system also, is it possible to give to make the mother as the natural guardian? That we have to see, because there may be a particular social ethos, a cultural ethos. A lot of things may come into play. So as I said in the beginning, ultimately, whenever we think of a child, we cannot give preference to a father over a mother or a mother over a father. The court has to decide that in giving preference to either of the parents, are we compromising upon the welfare of the child? So if a gender neutral law is made, it would of course make things much more easier for the courts also to decide, because here we are working with a presupposition that the father is the natural guardian. So the father definitely has an edge. We presuppose that while deciding any legal case that is before the family judge.
And the object is to that presupposition only.
Presupposition. So if you're all working towards that presupposition, that means that the mother who is fighting to be declared as a natural guardian, she's already on the weaker side. She's already has a lot of things to cover up before she can come and prove to the court that look, I'm equal. If not better, I'm equal. So I think that time has come where women have to stop proving themselves that they're equal to men or they're better than men. What we have to see is a woman is a woman, a man is a man, and a father is a father, a mother is a mother. So let them not, in that war that takes place, in that acrimonious mudslinging, acrimonious litigation that takes place in the court has to be totally neutral, and we have very, very eminent and distinguished judges who are heading the family courts in our country. And in my humble experience of about 33 years at the bar now, I have come across wonderful decisions where the court has been able to differentiate between the rights of a child and the rights of a parent who is fighting for the custody or the natural, to be declared as a natural guardian, and the other side who is defending. So ultimately, I do think that the courts have been able to do a lot of justice, and there have been even cases where you'll be surprised to hear that, where a particular father, I mean, I just was part of a case recently where a father filed a case in the family court that he should be declared as a natural guardian and the custody of his minor daughter should be given to him. And ultimately, the court juxtaposed the wife, who was the respondent, as the petitioner. And they said, no, enough is enough. The father has failed to prove his worth in any manner whatsoever. So it is high time that the wife, the mother, who was a respondent in that petition, she was juxtaposed as the petitioner and she was declared as a natural guardian, and the court thought her capable enough of being the natural guardian, of having the guardianship as well as the custody. So it is the merit of the parent which will prevail, not the sex.
And this particular example which you just cited also once again highlight the very fact where we started as the need to have the gender neutral laws based on the child-centric approach. Is that not it, Ms.
Yes,
Rajulakshmi?
absolutely. Why? Mainly because sometimes what happens is, in our society, the culture is such that, the child is always mother is emotionally attached to the child, and, we create a lot of, support system around that, saying that the mother is the emotional support, and for everything there is a mother, for everything there is mother. So with that, what happens is a lot of women feel scared also, and they are subject to domestic violence also. I'm not saying all women, but at times what happens is that need to be with the child, the social pressure around them also sometimes forces them, even if they are in abusive relationship, to continue because of the child. Because there is a law which says that suppose there is a separation, then the child will go automatically to the father. Yeah, so that way also, this is a very discriminatory law.
Need to have the gender neutral. So Shyam, do you agree with this point that this is the presupposition which is there within the law is something which is being objected to, and the solution lies in having a gender neutral law with, of course, a child-centric approach?
No, you're right, but giving this presupposition, if you go in the, if you see the proceedings in the court in these custody battles, I have seen many battles in the court. This law seems, yes, this is discriminatory, but when court, the parents go to the court, sometimes children also, the court say, we want to talk to the children also. So in the best interest, very recently there is a case of the Ghaziabad. Allahabad High Court has given the custody of a child who was less than 5 years old to the mother, as she was a natural guardian according to the law. But the husband challenged that custody and came to the Supreme Court. Supreme Court talked to both the parents, and it was a small child, but still court spoke to that child also. And after that, court said, no, father also needs to go with the child. So then court amended that order and said, ordered to the lower court, father should be given the visitation right.
But this can still be done.
How can you say
if the presupposition is done away with?
No, the presupposition is not done away with, but court goes with the factual situation which comes to the court. You can say this is this seems to be a discriminatory. But when actual things happen, you will find court say no, which is the best interest of the child, that will go.
Ms. Agarwal?
I would just like to add to that over here that, I fully, I know about the matter that the learned speaker is talking about. Here, as I can understand, the court totally reversed the order and gave the custody. So I will
did not reverse the order. The court amended the order.
Amended the order.
Visitation right should
yes,
be given
the
to the father
and that
also.
is why I may add over here that as a practicing lawyer in the family court, the court nowadays, earlier what happened, if I might just say that, the father was supposed to be some kind of a dragon, some kind of a rakshas. He's a bad father, because it was ultimately the private dispute between the wife and the husband, which was kind of tarnishing his image as a bad father. So now the courts are very liberal and very open to the idea that a man can be a very bad husband qua a wife, but he can be a good father qua his children. So definitely a father is not, he is a part of the birth process. So let not the mother just be treated as some like of a goddess who has given birth to a child. Oh, I'm my ma who is bacche ki. The ma has given birth, but the ma cannot give birth to the child alone. without the contribution of the husband. So let us not kind of victimize and be very skeptical over talking about fathers also,
but
because
both the
for a
parties
balance
will have to be brought on the
they have
same
been brought
platform.
to the same platform. The court only has to see who is the better parent, the better person, not whether you're a father or a mother. Just because you gave birth doesn't mean that you got a better right. You may have biologically given birth. That doesn't give you an edge up. And just because you're a father who's just earning bread and butter, and that doesn't mean that you're a bad husband and therefore you're a bad father also. So ultimately, the child has to be looked into.
Okay, final words from you, Ms. Rajalakshmi.
All I would say that you should be treated as a person, because a lot of time what happens is there is a possibility that a man genuinely wants to take care of his children. There is a possibility the women feels that she's stronger enough to take care of the children. So as Rekhaji rightly pointed out, it should be gender neutral, and at the same time it should go case by case. It should not be given as one law like that. It's case by case, because every family is different, family dynamics are different, the support system is very different, the way in the class is different, and so the context also at times is different. So therefore it's very difficult to actually have one kind of a uniform law or understanding.
Can I just add one last statement to this, that when you're talking about settlements that take place and when one partner decides to remarry, so I think the courts now must also look into these kind of settlements which are arrived at in the court, where the custody of a child is concerned, that okay, now the husband and wife are going to take a divorce in the court and the custody is going to be given to one parent. At the same time, there's a rider that if the father or the mother remarries, then that person has to hand over the custody of the child to the other spouse. So I think that is a very obnoxious way of looking at the idea, because remarriage is something which should be encouraged, and just because a particular spouse has decided to move on in life, the child cannot be treated as a chattel, that okay, I pick up the child and now from one house to the other, the mother is remarried, okay, therefore you go back to the father, or the father is remarried, you go back to the mother. So ultimately, I think that the rights of the child should be respected, that the child has got a mind of his own. And let the court arrive at that decision before handing over the custody or guardianship to any particular parent.
Okay, so there it is, as has been pointed by all our panelists. As far as the family laws are concerned, there has to be general neutrality in the laws itself, although as our panelists are pointing out, the respective courts do take note of that and are mindful of this particular aspect. But all of this has to be done with one and only one principle, that is with a child-centric approach, because ultimately it is the child who is at the center of this entire saga, and the onus on every party should be to ensure that child does not suffer because of the entire process. We'll come back again tomorrow with a different topic and different set of guests. Till then, keep watching Rajasthan.